Jason Bird.
Okay. Let's see. So I'll give you the courtesy I extend to all attorneys. I've gone through the paperwork. And I have set bonds at $5,000 for each offense for Mr. Bird, but I will give you the opportunity to advocate on behalf of your client when we get to that point.
Thank you, Judge.
So I just let you know what I've set so that you can prepare your arguments to the extent that you believe they're necessary.
Thank you.
All right, so we are live now. We'll start in a second, but I am looking at my computer, and for whatever reason, it's not bringing up the forms. So let me. Okay. So I apologize. This is something on my end, and apparently it's a technical issue because every time I click on the file for the CAA forms, it goes blank. So what I'm going to do is I'm just going to go and I'll do it contemporaneous at the same time that we're dealing with whatever person I'm dealing with. So do we need Miss Porter? Do we need a Spanish interpreter?
No, Judge.
Did you say yes?
That's a no, Judge. We do not need one.
Okay.
I see two possible LEPs on the calendar on positions 45 and 52, Your Honor, but I'm not sure. I'm just based on the name.
Okay. Would you tell me their names?
Yes, Your Honor.
Okay.
The position 45 would be Nelson Rivera. And then position, and that also goes for position 46, is the same person. And then position number 52, which is also position 51, it's Villegas, Cervantes, Sonia Yadel.
He said she does not need, neither of those individuals says that they need it.
Okay.
To be sure.
So thank you, Ms. Porter. It does not appear that we need you for today.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
Ms. Griggs, for Mr. Bird, I normally read like a script and then I get started, but he has a lawyer that's here who's representing him. If you don't need for me to read that script, I can bring Mr. Bird up right now and we can deal with his situation.
Yes, Judge, that would be great. I think it will be relatively quick.
Okay.
Based on the court's the statement the court already made in reference to signing bonds, I'm just going to make a couple comments.
Okay, can we bring Mr. Jason Quantavious Bird up, please?
Yes, Judge. It's on the way up. Yes, stand up. Yeah.
Mr. Bird, I would normally speak to you directly, but you've taken advantage of the opportunity to have a lawyer here to represent you. So I'm going to speak to your lawyer. I would advise you, though, sir, that this proceeding is not privileged nor is it private. So please don't say anything that you would not want the whole world to know. Do you understand that, sir? Okay. So Attorney Griggs, he's charged with two counts of possession of controlled substance. One count of it is possession with intent to distribute. And so the 2.7 pounds that allegedly were in his possession, flying from California, anything under 10 pounds, I can set bond on at this stage. So I've set bond at $5,000 on each offense. Is there anything you want me to know about this case, your client?
Yes, Judge, just briefly. Mr. Bird is 25 years old. He is originally from the metropolitan area. He did graduate from high school and attended 1 year of college. Both his parents are residents of Clayton County and are involved and invested in this, which is how he was able to retain counsel so quickly. Judge, he's not going to be a flight risk. He does have a passport, but right now he doesn't have access to it, and it may not be active from our conversation with his parents, who would guarantee that he's going to be in court. Based on his age and him looking for work, his parents are covering the majority of his fees. And so just based upon that, I would ask the court is amenable to perhaps reducing the bond to $2,500 per count in order to assist with some of the issues that his family is going to have to, or the monies the family is going to have to put up in order to make sure that he returns. He doesn't have any priors. This is his first encounter with the law. And I think that this is going to be something that is going to be a hard lesson for him throughout this process. So just based upon those factors, we would ask the court is amenable to reducing the bond.
I think I'm going to leave it where it is. Attorney Griggs, for me, there's when you start getting into these levels, it's not something that is like personal use.
Yes,
you
Judge.
know. So I generally, if it's personal use, I set the bond at $3,000.
Yes.
Because people they do what they do, but if it's something where it looks like this is becoming sort of a business endeavor,
Mhm.
then I set the bond higher.
Okay.
And so it just so your client understands, my position is that if this is going to be your business, you need to put money aside to take care of business.
Yes, Judge.
Attorneys we got to have malpractice insurance. We got to do other stuff. We got to spend money in other ways that we don't want to spend it. But when you get to, when you're talking about pounds of marijuana, to me, that's a business. And it's like, if that's what your business is, that's what it is. I'm not going to hold you in jail behind it. But at the same time, you're going to have to pay the cost to be the boss.
Absolutely, I understand, Judge. Are there any conditions other than those established?
Nope. He can make this bond by cash commercial property. So there's not anything other than the bond amount that's going to hold your client.
Thank you, Judge. I understand.
Okay. Anything else, ma'am?
Judge, nothing further on behalf of Mr. Bird.
Okay. Well, you're free to go. And Mr. Bird, you're free to go back.
Thank you, Judge.
You're welcome. Have a good day, ma'am.
You too.
Okay, let's start. I'm going to read the script. And it's going to be a little abbreviated today because we're starting a little bit behind. So this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Brad Gardner, and I'm a judge in this court, and I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But if you give up that right, anything you say during this proceeding could be held against you. So please don't discuss the facts of your case. You have the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to testify on your own behalf or offer evidence in your own defense. You have the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Each of you, if you're granted bond, you will have the ability to post that bond by cash, commercial, or property. Some of you will have special conditions on your bond that will prohibit you from going to certain places or having contact with certain people. If you violate those conditions of bond, you could be charged with aggravated stalking, which is a felony, and you could remain in jail until your trial. If a person is listed as a victim in your case, that person will not be able to post your bond. Some of you are going to be charged with offenses where this court cannot, by law, set bail. And in that event, a bond hearing will be scheduled before a judge of Superior Court of Clayton County, and you will be informed of that date. If you're currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand, please. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's begin with the ladies, with Miss Dillard.
Dillard, everybody else is gonna go back to here.
Ma'am, you're charged with 1 count of driving a vehicle with no insurance and 1 count of driving a vehicle without a valid license. The bond for each of these offenses is set at $1,000. Do you believe you can post that bond?
It's possible.
Did you say yes?
Yes, sir, it's possible.
Okay. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning. That's going to be in courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes,
Are you currently working?
yes, I am.
How much do you make per hour?
15.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes. So, okay, you say the bond, each of the charges is $1,000 bond. So if I was to like get someone on the outside to pay, like how much would I have to pay like to a bond company?
Through a bonding company, approximately $250
For both charges or just all together?
for the entire amount to get out. That's what you're asking, correct? So it'll be $250.
Okay, will I be able to like make a call to try to see if I can, get my bond on paid?
Would you be able to do what, ma'am?
Make a phone call to someone to get my bond paid.
Yes, you will be allowed to use the phone, but the sheriff's department, they have their own policies. I don't enforce what they do or not do. I do know that you will be allowed to use the phone, but they will tell you when you can use the phone.
I have another question.
Okay.
Once my bond and stuff get paid and whatever, will they drop the charges and I still have to go to court for it, or what? Like, I've never been in jail for it.
Okay. So the person that is making that decision is the Solicitor General of Clayton County, whether your charges will be dropped or not dropped. So I don't know what he's thinking about your case.
Okay.
Anything else, ma'am?
No, sir.
Okay, you're free to go back.
Your Honor.
Yes.
We skipped over Miss Collier. So can I bring her up now?
Let's see. Who did you said Collier?
Oh, never mind, Your Honor. She's a fugitive. I guess we're gonna do the
Last.
last.
Yes.
Okay, so I'll bring up Miss Finley.
Okay. Miss Finley, ma'am, you've been charged with 1 count of hit and run by accident, 1 count of failing to yield the right of way, or failing to yield the right of way when entering a roadway is how it's listed here. Both of these bonds are set by schedule, which means they're automatically set. So you're going to have a $1,500 bond for the hit and run charge and a $500 bond for the failure to yield.
Yes, sir.
So that's a total bond of $2,000. Do you believe you can post that bond, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, ma'am.
I'm sorry. Can you hear me?
I can barely hear you. If it would help when I ask a yes or no question, if you just shake your head, yes, I can see. Okay. All right, ma'am. Are you currently working?
Yes, sir.
How much do you make per hour?
Like 12.50.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Gardner.
Miss Gordon. Ma'am, you're charged with 1 count of simple battery, family violence. Bond's going to be set at $4,000. Do you believe you can post that bond? There's going to be a stay away provision on the bond to stay away from a Mitchell Green. Greenlee? Do you understand that? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? You said no? Okay. Do you have any questions of me? Okay, ma'am, you're free to go back. Ms. Hill? Ma'am, you've been charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from a symphonique Lewis. Do you understand that? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working? Okay, you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions? Okay, you're free to go back.
Johnson.
Ms. Johnson, ma'am, you've been charged with 1 count of criminal trespass, damage to property. This has been written as a misdemeanor. There's going to be a bond set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Calvin handbrake. Do you understand that? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I already have a lawyer.
Okay. Do you have any questions of me? Okay, ma'am, you're free to go back.
Lyles.
Ms. Lyles,
Yes, Your Honor.
ma'am, you've been charged with 1 count of battery bond. It's going to be set at $5,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from a Pierre Nunez. Do you understand that? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Do you say yes? Okay. Are you currently working, ma'am?
No, sir.
Okay. You qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Pippin.
Miss Pippins, ma'am, you've been charged with 1 count of hit and run resulting in accident. Bond's going to be set at $3,000 for that charge. 1 count of failing to yield the right of way as you enter a roadway. Bond's going to be set at $500 for that. And 1 count of driving a vehicle without a valid license. Bond's going to be set at $1,000. So that's a total bond of $4,500. Do you believe you can post that bond? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, are you currently working, ma'am?
Yeah.
About how much do you make per hour?
1750.
Okay, you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back, ma'am.
Pace.
Ms. Pace, you've been charged with 1 count of disruption of the operation of a public school. I've set a bond of $1,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your posting bond, and you'll get a new court date sent to you in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, it's okay.
Okay. Do you have any questions of me? Okay, you're free to go back, man. Ms. Collier, ma'am, you are what we call It's a term of art as a fugitive from justice. And what that basically means is that you're wanted from another state. They want to extradite you, and they've chosen to say that they will extradite you. And so you're wanted out of Beaufort County Sheriff's Office in South Carolina. Has anybody spoken to you about this process?
No.
Okay. So you have a right to file what is generally called a writ of habeas corpus, where you're saying, in it's a Latin term, but it translates into produce the body, where you have a right to be brought into court for a judge to make a determination as to whether you are the person named in the warrant and whether this charge actually exists. If you believe that you're not the person named in the warrant, or you believe that this charge does not exist, you may want to fight that process. If you choose to do that, then up from today up until 90 days, you will be brought into a court. And the thing that the judge will, whether you're the person named in the warrant and whether the charge actually exists. If that happens, the judge will then sign off on the governor's writ, which means it's just basically writ of extradition for you to be sent back to South Carolina. I can't tell you when that hearing will happen. I can tell you it will be sometime between now and 89 days from now. Once the judge makes that determination, if the judge makes that determination, there's going to be another 30 days up to a total amount of possibly 60 days. If you believe that you are the person named in that warrant and you believe that this warrant is valid, you can waive that whole process today and say, I want them to come get me now. And that 30-day period will, if you signed a waiver, that 30-day period begins to run today. And as I said before, they have up to 60 days. But if South Carolina decides that they're not going to come and get you, you can get released. But the warrant doesn't go away. So you can get released, and 5 minutes later, after getting released, you encounter another law enforcement officer, and they run your information, and they see that there is a warrant existing for your arrest, and the process just starts all over again. Do you have any questions right now as to what I've told you?
I am the person. Yeah.
I'm sorry, I can't hear you, ma'am.
That the warrant is for.
Your Honor, she's saying that she is the person named in the warrant.
Okay. Does she want to waive, or does she wants to challenge this?
No, I want them to come get me.
Okay. She wants to sign the waiver, Your Honor.
Okay, so ma'am, once you sign the waivers, the deputies will send it over to me and I'll sign it, and that clock will begin to run today. Okay?
Yes, sir.
Okay, ma'am.
Come over here.
Try each one of them.
You ready? Let me know when you're ready for the mails, Your Honor.
I am ready for the mails.
Your Honor, also about Ms. Whitsett. She's not going to be able to attend court today. She refused to come this second day.
There is, thank you for reminding me about that. I am going to enter an order. But well, I'm gonna go ahead and assign her charges, a bond for her one count of terroristic threats. And so there'll be a bond in the system for her. And when she ever chooses, shall she so choose to bond out, she will be able to do that.
What would the amount be so I can relay the message to her?
Let me see. It's gonna be $4,000.
He said, how much was it again? I'm sorry.
$4,000.
Okay, thank you, Your Honor.
No problem. Thank you for reminding me.
Thank you, officer.
All right, let's start with Mr. Arnold.
Mr. Arnold, come on up.
Mr. Arnold, sir, you're charged with one count of trafficking marijuana. This is one of those offenses that I cannot set bond. At this stage, the allegation is that there was almost 20 pounds of marijuana. I cannot set bond on anything over 10 pounds. So bond is going to be denied. I'm going to set a preliminary hearing date for November 22nd at 8:30 in the morning. I'm going to also set a bond hearing date for November 23rd. I'm sorry, December 3rd at 8:30 in the morning. Both of those going to be in courtroom 201. Do you want me to see if you qualify for appointed lawyer, or you're going to hire your own lawyer? I can't hear you, Mr. Arnold.
Yes, I want you to see you qualify for appointed lawyer.
Sir, get up off that wall.
He said, yes, Your Honor, he wants you to appoint him.
Okay. Are you currently working, sir?
I was, but not now.
Okay. I'm going to find you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? You said no? Okay, you're free to go back, sir.
Mr. Blackman.
Sir, you've been charged with one count of having a defective tail light and one count of having a defective tail lamp. Bond's going to be set at $500 for both of those offenses, and one count of driving on a suspended license. Bond's going to be set at $1,500. So that's a total bond of $2,500. You believe you can post that bond? Uh-oh, it's on mute.
He said, yes, Your Honor.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
No.
Okay. You're going to have a preliminary hearing date set for November 23rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. If you don't have any questions for me, sir, you're free to go back.
Can you repeat the bond again, sir?
$2,500.
All right, thank you.
Okay. Mr. Brown. Mr. Brown, sir, you're charged with one count of simple battery. Bond's going to be set at $4,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from Sierra robbers. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. Are you currently working, sir?
Yes, sir.
About how much do you make per hour?
$12.50.
I'm sorry.
$12.50.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir, thank you.
Okay. You're free to go back.
Carter?
Mr. Carter, sir, you've been charged with one count of simple battery, family violence. Bond is also going to be set at $4,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from a Destiny McGee. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, sir?
No.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back, sir. Mr. Dawson.
Your Honor, for Mr. Dawson, they're still trying to locate him.
Okay.
So put him on hold, please.
Okay, I'll put him at the end.
Okay, that's it.
All right, Mr. Is it Des Rosiers?
Yes.
Okay, sir, you're charged with one count of simple assault. The bond is set at $3,000. Do you believe you can post that bond?
Yeah. Yeah.
Okay, there's a stay away provision on the bond to stay away from, and Letta Watson. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
He said yes, Your Honor.
Okay. Are you currently working, sir?
No. He said
Okay. You qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
no. Right, come around here.
Okay. Mr. Fannin,
Order, sir.
good morning, sir. You're charged with one count of theft by shoplifting. It's a misdemeanor. Bond is going to be automatically set by schedule at $2,000. Do you believe you can post that bond?
Yes, I can.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, sir.
Okay, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Go, sir.
You are Mr. Grant.
Nah, go see her. Just go see her.
Okay. Okay. Hold on, stay right there. Sir, you're charged with one count of aggravated assault. Bond is going to be denied on that charge. One count of reckless conduct. Bond is going to be set at $2,000. One count of criminal damage to property in the first degree. Bond is going to be set at $5,000. And one count of possession of weapon during the commission of a crime. Bond is also going to be set at $5,000. I'm going to set a preliminary hearing date for November 22nd at 8:30 in the morning, courtroom 201. Would you like for me to, well, I'm also going to set a bond hearing date for December 3rd at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Sir, and can I ask how much is out it and out the total?
He's gonna tell you. Just wait.
You gonna tell me? All right. Yes, and I would like to see if I qualify for a lawyer.
Okay. Are you currently working, sir?
No, sir.
Okay, you qualify for the appointment of a lawyer. And so I set a bond of $12,000 on the other offenses, but I've denied bond on the aggravated assault. So even if you were to post the $12,000 bond, you would not be getting out of jail. Okay. Do you have any other questions, sir? Okay, you're free to go back.
Grant,
Mr. Grant, sir, you're charged with aggravated assault by strangulation. And I've looked at this, and I am setting a bond, but the bond that I'm setting is going to be $40,000. Do you believe you can post that bond?
No, sir.
Okay. There's going to be a stay away provision on the bond, stay away from a Don Lloyd. Do you understand that? I'm sorry, did you say yes?
Yeah, I understand, sir.
Okay. You're going to have a preliminary hearing date set for November 22nd at 8:30 in the morning, courtroom 201. The date will be waived upon your ability to bond out. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Okay. Are you currently working? Did you say no? Okay. You qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
You said no?
No.
Okay, sir, you're free to go back.
Mr. Hardnett, he was non-compliant, so he was taken back to the infirmary.
Okay, I'm gonna do a continuance order for him to appear on my calendar tomorrow. Got the trusty Post-it notes.
Okay, sir.
So Mr. Houston or Houston?
Yes, sir.
Okay, sir, you're charged with 2 counts of aggravated assault. Bond is going to be denied on both of those counts. 1 count of fleeing from a police officer, bond is going to be set at $2,000. 1 count of reckless driving, bond is going to be set at $2,000. And financial transaction card theft, bond is going to be set at $10,000. You're going to have a preliminary hearing date set for November 22nd at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for December 3rd at 8:30 in the morning, courtroom 201. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working? I'm sorry, sir. Okay. You qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Mr. Harris.
Mr. Harris, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $1,500. Do you believe you can post that bond?
No, sir.
Okay. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, Your Honor.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. I would also advise or caution you that you don't have to sit here in jail. This is a charge that you probably can get placed on a Tuesday calendar and have worked out.
Tuesday?
They do misdemeanors on Tuesdays. Your lawyer may be able to get you placed on a calendar so that you're not just sitting here if you can't afford to get out of jail. But I would also say that, you know, these are things where as a judge, I mean, you're brought before me, so I have to deal with it. But there are a lot of ways that this could have been handled other than placing you in custody. So I would just ask you as you move forward, there are places that you can go where you're not subjecting yourself to being placed in custody. Okay. I mean, and that's just if that's what you, I mean, if that's what you want, then that's what you want. But you don't have to do this.
I understand, Your Honor.
Okay. All right, sir. You're free to go back.
Mr. Holland? How you doing, Your Honor?
I'm doing well, Mr. Hollis. Normally, the people who are charged with this offense, they're able to bond themselves out before they come before me. The bond is set by schedule for this offense. It's a misdemeanor, but it's still set as a crime.
Your Honor, I just want to say, wait until the judge finishes talking, then he asks people if you have questions.
There is Mr. Hollis. So let me ask you this. Let me let you say what you were gonna say, because there are some things that I'm looking at as it relates to this, but I want to hear from you, sir.
I'm just trying. I'm just trying to say, you know, everything was in my name and everything. I just slipped in trying to hurrying up and going through TSA. I didn't try to bring that through. That's my gun. I don't have no record, criminal record, none of that, sir. And I'm just trying to say if I can get a bond with the 10%, because I'm not from here. Well, I stay with my cousin down here, but he stayed down here too. He got the ID and everything, but they saying like I got to pay the whole fine off.
Yeah, that's what I was seeing. And the reason that I wanted to hear from you, because when I saw this and read this, I was thinking of what I was going to do. So I'm going to dismiss this charge.
Okay, sir.
So once the paperwork gets back to the jail, you'll be free to go. So do you have anything else you want to say?
I just want to say thank you so much.
All right.
So
this charge is going to be dismissed.
thank you so much.
Okay. Mr. Lee.
Morning, sir.
Good morning. Mr. Lee, you're charged with 1 count of family violence battery and 1 count of simple battery. Bond is going to be set at $5,000 for the family violence battery, and bond is going to be set at $4,000 for the simple battery. There's going to be a stay away provision on this bond to stay away from Alicia, is it Seois? Klaus. Okay. They looks like they spelled it C-I. No, they did. They spelled it with an L. That's things getting old. My eyes start to go. Do you understand the stay away provision, sir?
Yes, sir, I do.
You're going to have a preliminary hearing date set on November 23rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me?
Yeah, what was the whole total of the bond, sir?
Total bond is $9,000. Okay, anything else, sir?
No, sir.
All right, you're free to go back.
The line.
Oh, could we bring Mr. Lee back real quick?
Hey, come back.
Yes, sir.
I forgot to ask, do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. Yes, sir.
Are you currently working, Mr. Lee?
No, sir, I'm not.
Okay, you qualify. I'm going to appoint a lawyer to represent you.
All right.
That was the question I needed to ask.
Yes, sir.
Okay,
Makes
Mr. Lyons. Sir, you're charged with 1 count of battery and 1 count of criminal trespass. There's going to be a $5,000 bond set on the battery charge and a $3,000 bond set on the criminal trespass. So that's going to be a total bond of $8,000. Do you believe you can post that bond? I'm sorry. Okay. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond to stay away from a Patrick Cobb. Do you understand that? Would you like for me to see if you qualify for the appointment of a lawyer? You said yes. Okay, are you currently working, sir? Okay, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Rivera.
Mr. Rivera, sir, you're charged with 1 count of simple battery, 1 count of obstruction of an officer. Simple battery bond's going to be set at $4,000. Bond for the obstructing of an officer is going to be set at $2,000. So that's a total bond of $6,000. Do you believe you can post that bond? Okay, your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working? Okay, you qualify, sir. I'm going to appoint a lawyer to represent you. Are there any questions of me? Okay, you're free to go back. Is it Suarez?
Suarez.
More Suarez. Okay. Sir, you've been charged with 1 count of theft by receiving stolen property and 1 count of carrying a long gun at the airport. I am going to dismiss the carrying of the long weapon charge. And I'm going to set a bond, because this is a felony offense, of $5,000 on the theft by receiving stolen property. So you have a total bond of $5,000. Do you believe you can post that bond?
Sure, sir. I doubt it. Once you ask a question, I can give you more information, but no, not as far as, not right now.
Okay. So What I heard was no, you don't believe that you can post this bond.
Not right now. I'm gonna need a couple days to maybe, make some calls. And whenever I can, I would like to speak to you.
Okay. You're gonna have a preliminary hearing date set for November 22nd at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond.
Okay.
You're gonna have, give me 1 second. I'm sorry, sir, were you talking to me?
No, Your Honor.
Oh, okay. So you're gonna have a bond of $5,000. You can post that bond and you will be released. You may want to consider whether you can go through a bonding company or not. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes and no. I working for my aunt. I'm an auto broker, and that was the situation. I got a car from Manheim auction, and that pistol was in the car. We were just cleaning out the car to resell the car, and I accidentally left that handgun in my bag when I was traveling. I forgot it was even in there. We were just cleaning out a car my aunt had bought. I had no knowledge of whose it was. I just was trying to get rid of it to resell the car, Your Honor.
Okay. So
But as
I'm
far
gonna find that you qualify for a lawyer. I'm going to appoint a lawyer to represent you. What I would suggest to you is that you speak to the lawyer about getting the documentation as to the purchase and all of that stuff as it relates to.
I have it all, sir, in my property.
Just hear me out.
I'm sorry, I apologize.
No problem. To have the lawyer present that to the district attorney's office, because they're the ones that are going to be prosecuting this case.
Okay.
So it's not whether you have the information, it's whether they believe the information.
Yes,
So share it with your lawyer so your lawyer can share it with the district attorney's office. And then you can hopefully this gets worked out.
yes, sir. Because it was not my gun, and I forgot we were just cleaning out the car. I travel and
Yeah, but all I'm saying is that as long as you possessed it, it was your gun.
I was unaware though, I just was cleaning out the car. I'm sorry. But like you guys said, I was in a rush trying to get home. But I understand. Thank you, John.
You're welcome. You're free to go back. Mr. Williams. Sir, you're charged with 1 count of obstructing or hindering law enforcement. Bond is going to be set at $2,000 for that. 1 count of giving a false name, address, or date of birth. Bond is going to be set at $2,000 for that charge. 2 counts of violation of Georgia Controlled Substance Act. Bond is going to be set at $3,000 for both of those offenses, and 1 count of use of possession of drug-related objects. So you're going to have a total bond set at $11,500. Do you believe you can post that bond? Okay. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working? Okay, you do qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for November 22nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me? Okay, sir, you're free to go back.
Your Honor, Mr. Dawson is coming through the doors right now.
Okay. It's right on time.
Mr. Dawson, right? Yeah. Come on, come over here, come over here. Stand over here. That's Mr. Dawson, Your Honor.
Mr. Dawson, you've been charged with 1 count of criminal trespass by coming back to the airport after you were told to stay away. I'm going to set a bond of $1,500 for that offense. I'm going to also appoint a lawyer to represent you. And I'm going to tell you that if you don't bond out, your preliminary hearing date will be set for November 23rd at 8:30 in the morning, courtroom 201.
Okay,
Do you have any questions of me, sir?
no further questions pending, Your Honor.
Okay, you're free to go back.
Okay, Your Honor, that concludes the calendar for the day.
Thank you for your patience
Yes, sir.
and your professionalism as always.
Yes, sir.
And have a good day.
You too, sir.
Okay.